I'm Jonathan Smith. I'm a partner and a solicitor at Poppleston Allen. We're specialist licensing solicitors based in Nottingham and London.
We're at the National Pubwatch conference today, and you gave an interesting insight into the agent of change principle. Could you just give us some insight into that?
Yes, so the agent of change principle was introduced through the National Planning Policy Framework, and it's clear that it's enshrined now within planning law. But the House of Lords Scrutiny Committee into the Licensing Act 2003 had recommended that the agent of change principle was also included within the Licensing Act 2003. It has been included as a simple paragraph within section 17 of the national guidance, but it's very weak. It's simply referring to the fact that the planning authority of the licensing authority should, when considering applications for flats, apartments which are being built next to noise generating premises, consider matters such as noise mitigation measures that should be put in place for the flats or apartments. We'd hoped that there would be something stronger in terms of the Licensing Act 2003, so that should a review be bought, say for public nuisance, by residents who are living in apartments or flats built next to noise sensitive premises, that cognizance will be had to the fact that effectively the noise generating premises was there first, and it was down for the developer, the builder of the flats or apartments, to have mitigated that existing legitimate legal noise generating premises by making sure the flats themselves were properly sound insulated.
I mean, you also took us through the impending changes to pavement licences, which are going to affect the industry quite dramatically. What's the impact of that likely to be?
So the Business and Planning Act 2020 introduced pavement licences to replace the tables and chairs licences granted under the Highways Act. There is separate legislation in London which governs it outside the Highways Act. So the Business and Planning Act 2020 is there already. It was due to come to an end, the transitional provisions permitting these payment licences, which are cheaper, quicker to get. It was due to come to an end at the end of September this year. But the Levelling Up and Regeneration Bill now proposes that these changes will become permanent, so that a payment licence can be issued for up to 2 years. Most councils will issue them for a maximum of 1 year, I suspect. They're cheaper, they're easier to get, there's a shorter consultation period, there's a shorter determination period, there's an easier renewal process. So for the trade it's good, because the whole process will become, or has been, more streamlined, quicker and cheaper under the Business and Planning Act, and those provisions will become permanent, so that you'll only make an application for tables and chairs under the Business and Planning Act 2020 now, rather than using the old legislation, which was more cumbersome and more expensive.
And the government's just launched a consultation proposing the relaxation of off sales and temporary event notices. What's your thoughts on this?
Good, yes. So the temporary event notices, again, as a result of the pandemic, the number of temporary event notices was extended for 2022 and 2023 to provide for, instead of 15 temporary event notice, you could apply for 20. And instead of those temporary event notices covering 21 days, they could cover 26 days. And the government's launched a consultation on whether or not that stops at the end of 2023, and those additional numbers will simply end this year, or whether they will be extended for a further year, for 2024, or actually whether that change will become permanent. Obviously for the trade, and it's a welcome relaxation that the 21 number of temporary event notices retained, with covering 26 days. And the second easement that they're looking for the relaxation on was around the off-sales provision. So again, as part of the pandemic, with everybody sat outside, they wanted premises to be able to provide alcohol to be consumed outside of the premises, in other words, an off-sale. So where your licence only permitted on sales, the Business and Planning Act, again, 2020, allowed those on sales premises only to also provide off sales. Now that permission is coming to an end at the end of September 2023 this year, and the government is now consulting upon whether that's it. So from the 1st of October, if you've just got on sales, then no more off sales, or whether it should be extended for a further year, or alternatively, a strange, rather left field suggestion that the pavement licence areas outside premises should be covered by the premises licence of the premises in question. So in other words, if you make the red line on sales area larger, it encompasses the pavement licence into the premises, and therefore you don't need off sales because every sale of alcohol becomes an on sale. The only downside of that is it doesn't actually extend it to your beer garden. So if you have a beer garden, say, to the rear, you would still need off sales and you'd still need to vary your licence. Again, I would hope that the government will decide to make that off sales relaxation permanent. Good for the trade.